So I think we went over the reasons why the insolvency of a financial institution is very different from the insolvency of any other brick and mortar company or a manufacturing company. That has been covered. We also discussed some of the peculiar issues which arise in relation to the bankruptcy code when it applies to a financial services sector company. And I think we also covered some of the interesting issues which arose in the ILFS bankruptcy, as well as the bankruptcy of DHFL. ILFS was even more interesting because that was something which has been resolved not under the bankruptcy code, but under the Companies Act, under section 241, 242 of the Companies Act, under which the NCLT has got plenary powers to design such reliefs as it deems fit. So we had something akin to a judicial innovation, where the NCLT came up with a mechanism through which to resolve a very complex group company, which was an insolvency with more than 300 subsidiaries and group companies. Many of them were financial in nature, many of them were operational in nature. It was around that time, I feel, that the government realized that such an ad hoc mechanism, even though it may have worked, cannot be a blueprint or cannot be the way forward for dealing with systemically important institutions which are facing financial distress. It was in that context that the insolvency code was extended to operate for other financial institutions. And that's where we have now IBC through section 227 of the IBC. It was extended for financial service providers, which includes NBFCs, includes insurance companies, pension companies, alternate investment fund managers, and so on. So this was, I think, the land which was covered yesterday. And today the intention is for us to cover two cases in particular. So I think, as Nilang may have mentioned yesterday, we have been quite fortunate to have worked with the Reserve Bank of India in all the financial service sector insolvencies which have taken place so far, which is DHFL, Shrey, and Reliance Capital. So today we will go over the learnings, our findings from Reliance Capital and Shrey. I will be covering Shrey, and you met my colleague Nilang, he will be covering Reliance Capital. So the idea is for me to take you through some of the interesting issues. I should not take more than half an hour to 45 minutes, after which I think it will be good if we can have some interaction in Q&A. And after that is over, then my colleague Nilang will join. Thank you. So, sorry, if you just give me a minute, I'll take out my slides. So by way of background, we are looking at two companies, SIFL, which is Shrey Infrastructure Finance Limited, and SEFL, which is Shrey Equipment Finance Limited. SIFL was a listed company. It happens to be the 100% parent of SEFL. Both these companies are based out of Calcutta, as many of you may be aware. The authorized capital of SIFL was about 1,500 crores, and the paid up capital was close to 500 crores. Its primary business was to be engaged in infrastructure financing, infrastructure advisory, investment banking, and insurance broking. And its turnover as on March 21 was 50 crores, and as on March 2022 was about 32 crores. SEFL, on the other hand, which is Shrey Equipment Finance Limited, its authorized capital was close to 1,000 crores, paid up capital was 79 crores, and it was engaged in the business of infrastructure equipment financing, technology and solution financing, healthcare equipment financing, agriculture and farming equipment financing, and used equipment financing. So very broadly speaking, you will find that SIFL was more into institutional financing, and SEFL was also financing small businesses and in certain cases even individuals for purchase of equipment which they may use in their personal agricultural or industrial purposes. Both SIFL and SEFL were facing financial distress. The total combined debt in SCFL and SIFL was close to 33,000 crores. There were payment defaults being suffered by to the lenders of SCFL and SIFL on account of various issues. One of the main issues, which in fact has been highlighted by Shrey itself, was that during COVID, many of you may recall that government had granted a moratorium on interest and principal repayment from borrowers. Many of the borrowers of banks and NBFCs got this waiver from interest payments, especially if they happen to be stressed or if they were below a certain size. But at the same time, NBFCs act in two capacities in our economy, right? They act as lenders and they also act as borrowers. So to the extent they had given loans to their borrowers got a moratorium on loan repayments. But the NBFC itself did not get any moratorium on loan repayment to its lenders. And who were the NBFC's lenders? They happen to be the large public sector banks. In the case of Shrey, it was UCO Bank, State Bank of India, Union Bank of India. Most of the important public sector banks were lenders to Shrey. So on one hand, the fund flow into Shrey from its borrowers had terminated. On the other hand, Shrey was still required to service the debt it had taken from its lenders. So there was a clear liquidity mismatch when it came to Shrey. A similar liquidity mismatch was also there in other NBFCs, but in Shrey, it was compounded by many other factors. So as per RBI, this is not something which I can vouch for. As per RBI, there were governance concerns in Shrey. There are allegations that the promoters of Shrey may have mismanaged the company. And there are also applications filed by the administrator of Shrey alleging that there has been misappropriation of funds prior to Shrey going into insolvency. So the root cause of distress is something which is not merely financial or merely linked to the economy. There could have been other concerns as well. Around 2 years back, there was a downgrade in the credit rating as well. The various credit rating agencies downgraded the debt. Shrey proposed a realignment or repayment plan, but the lenders were not in favor of it. There was also a slump sale which was proposed. So the entire lending business of SIFL, which is the parent, was proposed to be moved to SEFL, being a subsidiary, through a scheme of arrangement. So I'll discuss that in greater detail as we go forward. Finally, when things were not looking good and RBI could not wait for the account to deteriorate even further, RBI superseded the board of SIFL and SEFL on 4th October 2021, using its powers under the RBI Act, using its powers under Section 45 IE of the RBI Act. Soon thereafter, within 4 days of that, the RBI filed an application on 8th October under Section 7 of the IBC to initiate insolvency against both SIFL and SEFL. And soon thereafter, I think on 10th or 11th October, the matter was admitted and both the companies were put formally into insolvency. Now, to give you an overview of the Shrey Group, the Shrey Group of companies are a very complex web of companies. So you have, as I said, you have SIFL on top. Then you have two sorts of subsidiaries. Subsidiaries where SIFL has 51% and where subsidiaries where it is completely owning 100%. Amongst the subsidiaries which it owned to the extent of 51%, there is an asset management company called Trinity. Trinity acts as the asset manager in relation to various funds which were floated by Shrey. And these funds were investing both in debt as well as equity. So the point I'm trying to make is that within the same group of companies, Shrey would, or rather housed under the same group of companies, is the infrastructure business, equipment financing business, insurance business, as well as the asset management business, which Shrey owned. And that asset manager would directly or indirectly take equity control in the borrowers of Shrey. So on one hand, Shrey is lending to companies. On the other hand, Shrey is indirectly also controlling equity or the board of the same borrowers to whom it is lending. Whether this causes issues of conflict of interest or whether this is something which RBI or the ROC or SEBI is comfortable with. I'm not going to that at this moment. But the only point I want to highlight is that the financial structuring was very complex. On the one hand, Shrey was lending. On the other hand, Shrey was also indirectly controlling the equity in the same borrowers. And this point is important because ultimately, whatever recovery Shrey is able to make in the insolvency process from its underlying borrowers depends on these relationships, on whether the underlying borrowers are related parties, whether they have the capacity to pay, whether if they were taking into insolvency, whether Shrey will be a creditor in the COC of those companies or not. So this becomes very important in that context. So as I said, I think the most important issue which goes to the root of the whole insolvency process is a business transfer agreement. So the board of SEFL and SIFL in July 2019, they approved a business transfer agreement. The idea of the business transfer agreement was to transfer the lending, interest earning, and leasing business of SIFL, along with all associated employees, assets, and liabilities, to SEFL. So basically, the entire business of SIFL was supposed to be shifted to SEFL, along with all the assets and liabilities. This BTA was executed on 6th August 2019, and SIFL and SEFL entered into various assignment agreements between them for transfer of the assets and liabilities to give effect to the slump sale. Simultaneously, SEFL and SIFL also gave past relevant accounting entries in their respective books with effect from 1st October 2019, after receiving the approval of shareholders and few debenture trustees and a few lenders. And this was also made public on the stock exchanges. Now, the point to consider is that for the slump exchange to have taken place, there were two sets of consents that were required. One is from the shareholders of SEFL and SIFL, which was still within the control of the promoter group. And second was from the lenders of SIFL and SEFL, because those lenders had security or hypothecation over these loan assets which were sought to be transferred. Most of the lenders did not approve of this transaction. Some debenture trustees did, a few lenders did, and the stock exchanges took this on record. But when it came to meetings of lenders, the lenders voted down the slump exchange or the BTA. So we have a very peculiar situation where the legal steps which are required to give effect to the slump exchange, the slump sale, have not been taken. The relevant approvals have not been taken. But the company has given effect to the change, to the transaction in its own books of accounts. So it led to a situation where it was not clear whether the transaction has been given effect to, whether the transaction is void or it is voidable. There was a bit of confusion on how to resolve this dispute. Now, so when finally the company went into bankruptcy, the question was, if I'm a lender who had lent to SIFL and I did not consent to SIFL's business being transferred to SEFL, where do I file my proof of claim? Am I a lender to SIFL or to SEFL? So the administrator, in this case, gave liberty to all lenders of SIFL and SEFL to file their proof of claim in both companies. So you'll find that to some extent there was double counting in this matter because all claims were filed in both companies. As I go through the presentation, I'll explain how we resolved it and how we reconciled it. But initially, claims were filed in both companies. Soon thereafter, SIFL filed two applications under Section 230 of the Companies Act, proposing schemes of arrangement with all its secured and unsecured lenders. The idea of the scheme of arrangement was to ratify the business transfer. That was the whole idea. Now, NCLT Calcutta passed orders in October and December 2020 and gave the following directions. Number one, that creditors shall maintain status quo till further orders on their respective contractual terms under the financing documents. What does that mean? That basically means that till such time as the scheme of arrangement is being considered by the NCLT, lenders cannot enforce their security and they have to maintain a status quo. they cannot ask for the interest or payment of the principal till such time as NCLT disposes of the scheme of arrangement completely. Second, NCLT said that creditors and government and other regulatory authorities be stopped from taking any coercive actions, including change of status of account from being a standard asset, which may affect the implementation of the scheme. There was no doubt that Shrey was not able to service his debt by this time. But NCLT said that banks should not classify this account as a non-performing asset. Even if the debt has not been serviced for 90 days, you cannot classify it as a non-performing asset. Thirdly, the credit rating agencies of Shrey were also directed to not consider the non-payment of any dues to be a default and should not reduce revise the rating of the company from investment grade to sub-investment grade. And then finally, it directed meetings of lenders to be convened to take a vote on the various aspects which were proposed under the scheme. So what we have here is a very strange situation because, I think as all of you would be very well versed in Companies Act, under Section 230 of the Companies Act, there is no power given to the NCLT to issue directions such as this, where NCLT can impose a moratorium, where NCLT can tell banks not to classify accounts as non-performing assets, where NCLT can ask credit rating agencies to not classify certain accounts as sub-investment grade. There is no such power given under the Companies Act. So in the instant case, clearly, NCLT exceeded the statutory powers that it has to facilitate the scheme of arrangement. Now, various meetings of various creditors took place during this time, and majority of the creditors voted down the scheme. Meanwhile, an appeal was preferred to NCLT against the NCLT order, and NCLT order granted a stay on a portion of the NCLT order, which prevented credit rating agencies from considering the non-payment as a default. So CRAs were now given the authority or given the ability to classify defaults and to change the credit rating of the company. NCLT then further also granted a stay on the NCLT order where it stopped government authorities from taking coercive actions. So there were various other non-compliances, whether it be relating to RBI, SEBI, etc. NCLT had also stopped government action. Now, what you will find interesting is that these are the sort of actions which are prevented under the IBC. So once a company goes into IBC under Section 14, there's a moratorium which is imposed. So what NCLT essentially did was adopt the principles of moratoriums from Section 14 into a scheme of arrangement which was purportedly to be taken through Section 230 of the Companies Act. So this is something which, at least in my limited experience, was without precedent, where NCLT would act beyond the limits of the statute under the Companies Act. So now, when the company finally went into insolvency, as I said, we were faced with a very difficult problem because it was not clear what is the correct financial position of SIFL and SEFL. Do the assets belong in SIFL or do the assets belong in SEFL? Because the balance sheets have changed, but the legal consents were not there to give effect to it. Secondly, now we are faced with a moratorium. Under a moratorium, you cannot alienate any assets of the company once the resolution professional takes over. So as the resolution professional, am I authorized to say that the assets which have been transferred to SEFL shall now be transferred back to SIFL? I'm not sure if I have that ability. As the administrator, as the resolution professional, I'm not sure if I have that ability within the contours of the IBC. So it left us in a very peculiar situation where we didn't know how to allocate the assets. This is where we thought about a group insolvency. Because if we packaged SIFL and SEFL as one product, then it does not matter where the assets are. Whether they are in SIFL or whether in SEFL, it does not matter. Because we are no longer selling individual companies along with their assets, we are selling the collective, selling the whole entity, SEFL plus SIFL, along with their total debts total liabilities, and total assets. So it does not matter where the assets are lying because everything is being sold anyway. This is what we wanted to achieve. But to achieve that, we would have to file a consolidation application before the NCLT to say that these companies are now consolidated and will be sold as one. Many of you would have, read about the Videocon case and the Lavasa case in the context of IBC on how can you conduct a group insolvency. I think Mr. Batra has also worked extensively on this point. So what are the various factors which govern group insolvency for consolidating 2 different or 3 different group companies and conducting it as one consolidated insolvency process? So those factors were laid out in Videocon. You will also note that in the statute, in IBC, there is no provision for doing a group insolvency because IBC treats each individual company as a distinct legal entity, and those insolvencies have to be conducted independently and separately. There's no provision for a group insolvency. But this is a judicial innovation which came up in the Videocon case and was subsequently also used in the Lavasa case. And the factors governing consolidation are as follows. If there's common control, if there are common directors, if there are common assets, common liabilities, there is interdependence of business and operations, interlacing of finance, pooling of resources, there is a need for them to coexist for their survival. There's an intricate link of subsidiaries. There is intertwining of accounts. There is singleness of economic unit. There is cross shareholding. There's interdependence due to intertwined consolidated accounts, and there's interlooping of debts. These are 14 factors. If these 14 factors exist in 2 insolvent companies, then you can make an application to NCLT for seeking a consolidation of those 2 companies. So let's see whether all these factors, how they apply vis-a-vis the Shrey insolvency. As far as common control is concerned, SIFL, as we know, is the holding company and promoter of SEFL, and SEFL is a wholly owned subsidiary. So on that count, there was element of common control. Common directors, both SEFL and SIFL shared 5 common directors. And further, after the insolvency process began, the same administrator was appointed for both these companies. There was not 2 distinct individuals who were appointed. There were common assets. There were multiple loan assets where both SEFL and SIFL had extended loans to the same borrower. And a substantial part of SIFL and SEFL's business consisted of structured finance, wherein financing was given by, say, SIFL or SEFL via debt, and equity infusion had also been made directly or indirectly through various layers of borrowers using the Trinity, which was one of the investment managers. Further, there were common liabilities. 86% of the financial creditors, holding 97% of the voting share of the COC of SIFL, were also members of SEFL COC. So there was a huge overlap in the lenders between SIFL and SEFL. There was also interdependence. The business of SEFL and SIFL are interconnected and interdependent. SIFL was engaged in infra finance, infra advisory, investment banking, and insurance broking. And SEFL was engaged in infra equipment financing, technology and solutions financing. And they were using common resources. There was pooling of resources, as I said. There was common human resource, common liaising and funding. And the affairs of both the companies were collectively managed. It was very difficult to say that whether an employee is managing the affairs of SIFL or SEFL, because it was done in a very commingled way where you could not differentiate. Given the intricate relation between both the companies, disentangling the assets and other interlinkages between the 2 companies would be a very time-consuming process and will frustrate value maximization. Moreover, the subsidiaries and affairs of SIFL were also intricately linked with SIFL. So there was common subsidiaries. There were common accounts. SIFL prepared consolidated accounts with SEFL. And lastly, both entities ran their business operations in proximity, in physical proximity. They were both mutually dependent. They used the same resources and funding. Therefore, looking holistically on the 14 criteria which Videocon had laid out, it appears that SIFL and SCFL were ripe for consolidation. And NCLT Calcutta subsequently gave an order consolidating both the insolvencies. The consolidation order noted the following: that the CIRP of SIFL and SCFL shall stand consolidated with immediate effect. The administrator shall forthwith constitute a unitary and integrated COC to conduct the CIRP of SIFL and SCFL, and the administrator shall conduct all requisite processes in a concerted manner, which means call for consolidated resolution plans for both SIFL and SCFL. So to come back to the initial question with which I started, or the issue with which I started, which was how do you disentangle or how do you pick apart this BTA, the business transfer agreement? So we were not able to. And therefore, we lumped everything together under one umbrella and we sold it together.
Suhash, your network is weak, I think, because your picture is frozen. We can't hear you. Is any colleague of Suhash online?
Hi, this is Amrita. I'm just reaching out to him.
Yeah, okay, Amrita. Thank you.
Sorry, I'm back. I think I lost connectivity for some time. I'm back. So sorry, I was saying that the other issue is something which we touched upon briefly yesterday, is the issue of third-party assets. So both these companies, SIFL and SCFL, as we're aware, were NBFCs. And what they had done was that they had securitized many of their assets, right? So they had sold many of the loan receivables that they had. They had securitized it or sold it to certain banks and financial institutions, which means that as and when recoveries happen from those loan accounts, those may have been held by SIFL or SCFL temporarily for the purpose, but for the only purpose, sole purpose of passing it on to the underlying end beneficiaries. Now, there are various securitization structures. There are certain structures in which SIFL, where the originator will act as the servicing agent. There'll be many structures where the money itself does not come into the balance sheet of the originator and is put in a separate designated account, so that there's no commingling between the originator's assets and the assets which belong to the securitization beneficiaries. There are various permutations and combinations in which a securitization transaction may be done. In the instant case, what had happened was that many public sector banks, including State Bank of India, Punjab National Bank, Bank of Baroda, etc., had entered into these securitization transactions with Shrey. So, as on insolvency commencement date, the allegation by Punjab National Bank was that an amount of up to 848 crores was collected by Shrey in its capacity as the originator of the securitization, but those amounts were not paid to the intended beneficiaries of the securitization. And they were in fact used for other purposes. So the pool lenders, the securitization beneficiaries, they had entered into independent and separate deeds of assignment and servicer agreements with SCFL, Through those deeds of assignment, SCFL had assigned its entire right, title, interest to receivables from certain select customers to the pool lenders in exchange for the purchase price. Under both the servicer agreement, by the servicer agreement, the SCFL or any entity appointed by SCFL was to service and assist in debt collection and recoveries in exchange for a certain service or fee. And the receivables would be to be deposited in a distinct collection and payout account. Now, what happened was that after the administrator took control of the company, he took note that the receivables were collected from time to time, but a certain portion of the money was not deposited in the collection and payout account. It came into the account, but it went out not to repay the lenders who were, or rather, let me not use the word lenders, not to repay the securitization beneficiaries, but to repay on balance sheet debt of SCFL. So the money which SCFL should have idly collected and held on trust to pay to those to whom a true sale of the receivables had taken place, that did not occur. Those monies were allegedly misutilized and used to discharge on balance sheet debt of SIFL and SCFL. So the entities which had purchased the receivables on a true sale basis, they questioned this transaction and basically said that the SIF and SCFL should set aside 848 crores exclusively for their benefit. Post the initiation of bankruptcy, the trust and retention account continued to exist, but now because it was under the supervision and control of the administrator, there was no further mismanagement. But what about the amounts which had initially been collected but were paid out? Who was responsible for repaying those amounts? And more importantly, the securitization beneficiaries who lost these amounts, access to these accounts, how should they be classified in the insolvency process? Became a major question. Should they be classified as financial creditors of SCFL? They have not lent money to SCFL, right? They have in fact purchased assets from SCFL. They purchased the receivables from SCFL. So it's questionable whether they can be classified as financial creditors. If they are not financial creditors, can they be classified as operational creditors or other creditors? Or alternatively, they're not creditors at all, because to them certain amounts were given up. They were legally entitled to those receivables. If those receivables don't end up in their pockets but have been diverted for other resources, for other purposes, then are they a creditor at all, or do they only have a claim in law saying that these amounts should be traced and handed back to us? So this is a matter on which I may have a personal view, but this is also a matter now which is currently sub judice. The next issue which arose is similar. I think yesterday my colleague Avinash may have discussed this with you in the context of DHFL. There was some litigation vis-a-vis National Housing Bank, NHB. So similar, this is very similar to the NHB litigation. There are two sections under the NABARD Act and the SIDBI Act, which I'll just read out for your benefit. Section 29(1) of the NABARD Act basically says any sums which are received by a borrowing institution, in this case SIFL, in repayment or realization of loans and advances refinanced either wholly or partly by the National Bank, which means NABARD, shall, to the extent of the accommodation granted by a National Bank and remaining outstanding, and this is the important part, be deemed to have been received by the borrowing institution in trust for the National Bank, and shall accordingly be paid by such institution to National Bank as per the repayment schedule fixed by the National Bank. SIDBI Act has something very similar. In fact, the language is remarkably similar. It says any sums which are received by a borrowing institution in repayment or realization of loans and advances refinanced either wholly or partly by SIDBI shall, to the extent of the accommodation granted by SIDBI and remaining outstanding, be deemed to have been received by the borrowing institution in trust for SIDBI. and shall accordingly be paid by such institution to SIDBI as per the repayment schedule fixed by SIDBI. So what is the effect of these two sections? It's very similar to the effect of the NHP section. It basically means that if NABARD has given a loan to SIFL, SIFL has used that loan to give loans to its underlying borrowers, then any repayment from those borrowers shall be held on trust for SIFL and can by SIFL for the benefit of NABARD or SIDBI, as the case may be, and cannot be used for any other purpose. Now, the supplemental question that arises over here is what happens in case the loans which have been tagged as having been financed through the SIDBI or NABARD loans, if those receivables have also been secured in favor of other secured creditors of the company? Because then you have a conflict. The conflict is that on one hand, NABARD and SIDBI is claiming an exclusive trust over those assets. On the other hand, there are other secured creditors of the bank, of the company, who have a hypothecation over all the receivables of the company. So whether the trust prevails or whether the security interest which has been created in favor of the banks, that prevails. Interestingly, there's also a consortium agreement where NABARD or SIDBI may be a part. So can on one hand, NABARD and SIDBI say that they are trust beneficiaries, and on the other hand, can they say that we have a security interest in the property, because these are mutually destructive pleas. But that is factually what has occurred in this case. Also relevant here is Rule 10 of the FSP rules. The Rule 10 of the FSP rules basically says that it requires the administrator to take control and custody of third-party assets or properties in custody or possession of the corporate debtor, including any funds, securities, and other assets required to be held in trust for the benefit of those third parties, for the purpose of dealing with them in the manner as may be notified. So basically, the FSP rules say that if you are the resolution professional in relation to an FSP, assets which you're collecting, which are either contractually or statutorily supposed to be held on trust for other parties, you shall keep that segregated and you shall hand it over to those third parties. There is no dispute on this point. The issue, however, arises is what about those assets which were used or misused for other purposes before the administrator came in, like what happened in the case of pool lenders. While he is in control, he can obviously watch over and supervise. But what about those assets which were misutilized or siphoned off illegally? Or rather, if not illegally, then in breach of contract. How will those funds be traced and returned? Also relevant here is Section 18 of the IBC, which says that the resolution professional shall take custody and control of any asset over which the corporate debtor has any ownership rights, as recorded in the balance sheet of the corporate debtor. The term assets does not include assets owned by a third party, which are in possession of the corporate debtor or held under trust or under contractual arrangements, including bailment. So IBC itself, even without the FSP rules, was very clear that if you're holding assets on trust for third parties, you're merely acting as a custodian. It is not your asset and cannot form the part of your liquidation estate. So this, again, as I said, is a matter which is sub judice. It'll be interesting how it pans out. Now, where we are in terms of the process today is that the CIRP process is over. It ended on, if I remember correctly, 18th February. The NARCL, which is the bad bank established by the government, National Asset Reconstruction Committee Company Limited, has obtained the highest votes in the resolution process, and they were selected as the successful resolution applicant. In terms of the process, an application has been filed before the NCLT under Section 31 for approval of the application. And simultaneously, an application has also been filed before the Reserve Bank of India on which will determine whether the new resolution applicant is fit and proper to take over the company. And under the FSP rules, RBI has 45 days to grant its consent, which, if not obtained, will lead to an automatic deemed consent. So that's where we are in terms of the process. as the matter is currently in NCLT, there are various applications which have been filed opposing the Section 31. Many of those relate to inter-creditor issues. As I said, applications have been filed by NABARD on SIDBI in line with the NHB application in DHFL. Applications have been filed by pool lenders, and applications have also been filed by certain unsuccessful resolution applicants. But I will not go into that for the purpose of this discussion, because that's something which happens in all companies, not necessarily only relating to financial services companies. So, sorry, I think I've taken close to 55 minutes. This is a very broad overview of the stray process and where we are currently. I think it'll be useful now if we open the floor in case there are any questions, and we can address that.
May I raise a question here?
Yes, sir, please.
You said in the process of your deliberation that the NCLT initially directed to banks and credit agency not to consider the even after default NPA, and to credit agency not to consider the default in their credit rating.
That's right.
And you also said that there is no such provision in the Companies Act which empower NCLT to give such kind of orders.
That's right.
In the same way, later on you said that the NCLT directed to merge the CIRP process, and in some realty cases we have seen the demerger of the CIRP process also.
Yes.
So my question here also is, if there is no provision in IBC as such for merger or demerger, from which act or which power NCLT is drawing power to guiding these kind of things?
So you're absolutely right, sir. There is no power in the IBC which allows NCLT to consolidate or merge two ongoing CRP processes, or to demerge in the, as you mentioned, the case of real estate companies. There is no power under the IBC. As I said, this is a judicial innovation. I think after the Videocon case was decided, there was broad consensus that there is a gap in the law, especially for companies, groups of companies which are all insolvent, or they have made a payment default, all of whom have certain commonalities, common directors, common assets, common liabilities, interdependence, etc. If those factors are there, then it will lead to a more holistic resolution of the company. Also, to add to that, this is an application which is filed not merely by the resolution professional, but this is something which the Committee of Creditors deliberates. It's after the Committee of Creditors, who is a very interested and affected party, deliberates this. They are also co-applicants at the NCLT. So the only distinction I'll make is that in the previous case of Section 230, where the scheme of arrangement, the NCLT passed certain orders under the scheme of arrangement, it was contrary to the submissions made by the lenders and the credit rating agencies. Whereas in the case of group insolvency, whether it be Lavasa, Videocon, Shrey, or any other company, the lenders themselves have come before the NCLT and said that if a consolidation does not take place, it will lead to value depletion, and the purpose of value maximization will not be achieved. But to answer your question very directly, sir, there is no provision under the IBC. This is a judicial innovation, and the government is very aware of it. In fact, the government has set up a committee on group insolvency. That report has also been published, and one of the recommendations is that the law be changed to specifically allow something which NCLTs have been doing through judicial innovation.
Thank you for your submission. But my question is academic in nature, basically. Like you must be knowing, initial days when Section 12A was not there in IBC, the Supreme Court utilized power under Article 142 to allow the withdrawal of the CIRP process. But later on, the committee formed and the recommendation were made, and thereafter, after the direction of the Supreme Court to consider the provisions for withdrawal, Section 12A incorporated in the IBC. But in this case, I wanted to just for academic purpose, from which article or which section the judiciary draw its power to regulate like this or give order like this?
So, sir, there is no power. I'll be very honest. In my view, at least, there are other legal experts, there is no power. There is Rule 11 of the NCLT rules, which says that the NCLT has got plenary powers or can take certain actions in the interest of justice. Supreme Court has held in certain contexts that the Rule 11 of the NCLT rules cannot be used by the NCLT in a very broad manner. It has a very limited purpose. It is similar to the powers which a civil court has under the CPC. It cannot be used carte blanche in any matter. So your point is well made, sir. There is no statutory provision, but I think the point to note here is that this is a commercial court, and the commercial court has come up with a solution where all affected parties have no objection to it. If you see the Videocon case where consolidation of 13 companies happened, there were a few other companies which were not consolidated because the lenders of those companies had objections, the promoters had objections, and those commonalities were not found. So even though there is lack of legislative sanction for this, I think the fact that it is a commercial solution, no party is affected. All parties, in fact, will benefit from a consolidation. The government and higher judiciary has, for lack of a better word, tolerated this judicial innovation. The government appreciates that this is a requirement, and hopefully there will be a change of law soon to give effect to introduce provisions of group insolvency in the IBC itself.
Thank you, sir.
Suhash, can I supplement a little bit?
Of course, sir. Please, sir.
So there are two principles of law which are quite emphatically embedded in our jurisprudence. In respect of the tribunals cannot use their inherent powers to vest in themselves the jurisdiction that the parliament has chosen not to vest in them. Like, for instance, the power to review their own orders in the case of NCLT. It is now a very subtle jurisprudence that NCLT doesn't have the power to review its own orders because the legislature has chosen not to vest that power, while they had the option to do so. The second principle is very clear that there is always a reason why an inherent power is granted to a tribunal. That inherent power is granted in order to empower or equip the tribunal or any such court to not feel handicapped or constrained in the absence of any specific power, where they feel constrained in any manner to pass any orders to meet the ends of justice. Okay. Now, in the case of Videocon, which was the first instance where the court, by jurisprudence, ordered procedural consolidation, was, although I hope and wish that the judgment could have been better written than it was, but no offense meant, the principle on the basis of which that order was granted was threefold. First of all, that there is nothing in the code that prohibits a procedural consolidation. So there may not be a specific enabling provision to allow consolidation, but at the same point in time, there is nothing in the code which prohibits or in any manner restricts such consolidation. Number two, the power to exercise consolidation was exercised to meet the objectives of the code without, as Suhash very clearly mentioned, impacting any of the parties adversely or causing any prejudice to any of the parties. And third, that the procedural consolidation as an outcome of the decision of the NCLT also and I'm not talking jurisprudence now, I'm talking of the actual order. The actual order directing procedural consolidation also did not in any manner conflict with any of the provisions of the code. The fact is that there is no restriction that an common RP could be appointed for 10 entities. And therefore, when an common RP was appointed, there was no violation of any. There was no orders saying that the COC would be merged or that there'll be a common COC to all of that. So, Sir, if I remember correctly, Videocon did not say that, there'll be a common COC. Did it? At least I don't recollect, but remind me because it's been a while. At least the way we had argued, Saharsh, before the Videocon, and when we had actually persuaded State Bank of India at that point in time that they should file an application. And there was quite a lot of challenge in persuading all the RPs who had already been appointed in different entities to come together and agree to that proposition. But finally, when SBI did file an application, they just wanted procedural consolidation. Although, of course, we did say that there are instances in our jurisprudence of substantive consolidation, but we thought that this is possible. And that is why the NCLT was persuaded. The reason for that was, as Suharsh also mentioned, to meet the objectives of the code, to preserve the value, to make the process more efficient, and to, at the end of the day, meet the objectives of the code, which requires the maximization of the value for the benefit of all the stakeholders. So in my view, even though there's no specific provision, even though there is nothing which vests a specific jurisdiction, the NCLT to order consolidation, we did feel that there is a small window which is available, which we can use without in any manner offending the law or offending the established principles, or in any manner asking the NCLT to exceed its jurisdiction to pass that order. Now, the very fact that those orders were never set aside or upset by any higher court, although they were frowned upon initially by the policymakers, because that was not a policy choice that was made in the IBC, and therefore they rightly felt that perhaps the order of NCLT could be seen to be having some tension with the policy as articulated in the code. But at the same point in time, the lenders or the policymakers saw merit in giving this a policy shape, and that's why, as Suharsh mentioned, that a working group was constituted. And it's a different matter that the working group report did not get immediate traction, but it is back on the track, and hopefully we will see it soon. So I do agree with what Suharsh says in all respects, but I just wanted to provide another dimension as well.
Thank you, sir. Thank you.
I mean, as per your view, the NCLT draw power under Rule 11, which Mr. Sinha referred to deliver the judgment, like Supreme Court draw power under Article 142 for withdrawal.
So Article 142 cannot be compared at all with.
I'm not comparing. What I'm just referring. Once for withdrawal, when the 12A was not there, the Supreme Court draw power from 142. Similar way, do you want to say that NCLT draw power under Rule 11 to deliver the judgment?
So yes, I mean, the NCLT did use the power under rule, and they were persuaded by the arguments of the councils in that case to show that such an excess of the power is permissible to achieve the object that the parties were wanting the court to order on, and they would not be in any manner contrary to any law or any legal provision, because inherent power cannot be exercised to act contrary to what the law provides, isn't it? So the argument was that it would not be in any manner seen to be in conflict with any provision, substantive provision of the code. While there is no specific provision enabling the group the consolidation, but there was nothing prohibiting it as well. So it was an experiment. It was an innovation, which also Suharsh mentioned. It was, and that also, incidentally, if I may tell you, 3 days before the judgment was reserved in Videocon, the Swiss ribbon judgment came. And this last paragraph of the Swiss ribbon judgment, if you recollect, where Justice Nariman said that it is an economic law, it's a new law. It is an economic law, and we should not be afraid of experimenting. So this, in fact, only emboldened the lawyers who were arguing in favor of consolidation to persuade the NCLT. It is an experimentation. It's an act of innovation, and let's just give it a shot. So I think we should move to the next point, Suharsh. I know it was an academic discussion, but I thought,
Okay. Any questions?
Thank you. Thank you.
Thank you, Mr. Bankar. Any more questions on the Shrey issues that we discussed?
Participants can ask the questions if they have any. So I think no more questions are there for this topic.
Okay, so in which case I'll hand over to my colleague. Nilang is already here. Over to you, Nilang.
Thank you. So onwards from Shrey to the last in the Trimurti, so far anyway, of Reliance Capital, of financial institution insolvencies. As I was saying yesterday, and I want to just remind the group today, the difference in the business models and the structures of the 3, even 4 financial institution insolvencies that we've seen. You all remember how my partner Amrita described ILNFS, being a sort of a group entity which used its investment in downstream entities to raise a lot of the funding and then invested in downstream opcos with certain limited amount of operations at the holdco level. Dewan Housing, which was, I suppose as close to a shadow bank as is possible, deposit taking and actually doing significant retail lending. In fact, its retail banking or retail lending arm was huge compared to its other operations, and that's really what the bidders there were buying. Moving on to Shrey, as Suash just described, more on the asset finance and leasing business model. And finally, Reliance Capital, which very much is, in a sense, an in-house investment vehicle. It sits at the top of many of the ADA Group's, financial businesses, whether it's stockbroking or ARC or investment advisory, or in fact, Reliance General Insurance and Life Insurance, the insurance companies. So this sits at the nodal top of all of these entities. It sits as a CIC, a core investment company. It's a type of NBFC. There's certain tests which you have to fulfill in order to become a CIC. And if you do become a CIC, although you are an NBFC, the amount of regulation you suffer from is reduced, which is why these entities take on the CIC tag. The Reliance Capital story is a bit of an old one. They've had reasonable assets. They've had a lot of liabilities. I think there was a lot of inter-creditor infighting disputes in terms of who had access to security, who had valid security. And in the process, I think a lot of creditors went in and got status quo orders from various courts around the country and basically locked up the resolution, of Reliance Capital. So if there was any chance of it being processed outside the IBC, I think the interlocking status quo orders and the inter-creditor disputes was going to make it very time-consuming and difficult to resolve out of IBC. Now, obviously, IBC comes along as a bit of a sword to cut the knots in the rope, if you think about it. And so I think eventually, November 21, the RBI came in and said, we need to supersede the board. And following supersession, in just about a week, instructions came in from RBI to admit the company into IBC. And I think first week of December, Reliance Capital was admitted into IBC. As before, administrator appointed, advisory committee appointed with 3 members. And the process has been running since December 2021 and continues today. The total debt is about 30,000 crores. The progress, as some of you will have read in the newspapers, is significant. Expressions of interest have gone out. A lot of PRAs were interested, about 55 of them were interested. As often is the case, many of those tend to peter out at the time of actual submission. There were a fair number of people who submitted their actual resolution plans in what we're calling like the first stage. I think more recently it petered down into only 4 participants, and now, as you'll have seen in the news, for now there seem to be only 2 participants: the Hinduja group and the Torrent group. 3 or 4 curiosities in relation to the RCAP process, which I'll go into. I won't be able to give too much detail because some of these are still sub judice, some of these are still being, argued and negotiated in the COCs and in the courts. So you'll forgive me if I'm a little low on detail. But one very interesting facet which comes out, and although it is inevitably going to be relevant to every CIC, it may also be relevant to non-financial firms. And this is the issue of there being multiple business lines in a single company. And as I was saying earlier, the way RCAP is set up, you have a CIC at the top and multiple companies or investments in multiple companies rooted into the CIC. So, you have your general insurance company, the life insurance company, you have an insurance brokerage, you have an investment advisory, you have an ARC, a whole bunch of these. Now, I think the obvious economic question for the COC was, I forget, there were two NBFCs, Reliance Home Finance, Reliance Commercial Finance as well. So the obvious economic question for the COC is there one buyer who wants all of this and is therefore willing to pay a premium to get the right mix, the right basket, the right thali, all at one shot? Or is it the case that there may not be one buyer who values every one of these entities and therefore may give good value for 4 of the 10, and 6 of the 10 he's forced to take and therefore will give them some nominal value? And therefore, is it better if we say that people can buy what they want, right? You can buy 2, you can buy 1, you can buy 3, you can buy 3, and therefore the sum of its parts effectively may be greater than the whole. Now, no one obviously knows the answer. Everyone can speculate. And therefore, the COC took a call, much like the call that was taken in DHFL, which was that let's test what value we can extract by trying to sell them individually as well. Now, we all know the requirement under the IBC that the company must be resolved as a going concern. So how does that fit into this concept? And it was the broad similar analysis we did in DHFL, which my partner Avinash spoke of yesterday. And my partners Avinash, Suhash, and I, all 3 of us did Diwan Housing together. So we were very conversant with the call we took there. The call we took was, yes, the principle of resolving as a going concern, the entire company applies. But that does not mean that you can't get separate resolution plans for individual lines of business, which you coalesce into one overall plan, which effectively read together resolves the entire company. To which the obvious question you might ask is, what happens if Jimmy, Johnny, and Jack get together, and then when it comes to the resolution plan implementation stage, one guy falls away and says, I won't implement? Does it mean the entire plan falls? Does it mean the rest of the company can go on? Obviously, a fail-safe mechanism needs to be built into the resolution plan by the COC and the administrator, and has to be signed off by the NCLT. Now, what this is, I won't go into detail about, but suffice to say that this is something we had contemplated. And therefore, the structure which was set out in the EOI was, please come and buy any one of these 8 clusters. And each cluster had a group of companies. So, for instance, cluster 1 had RGIC, cluster 2 had Reliance Life, RGIC is Reliance General Insurance. Cluster 3 had Reliance ARC. Cluster 4 had Reliance Securities, Reliance Financial, Reliance Wealth Management, Reliance Commodities. Cluster 6 had Reliance Home Finance, 7 had Reliance Commercial Finance, and so on. So there were these 8 clusters, which basically divvied up the various holdings into more logical, edible, snack-sized entities. The thinking was, someone who takes a Reliance Securities may be equally open to then taking Reliance Financial, Wealth, and Commodities, and therefore we put those in, or COC put those in a group together. The idea was you could choose mix and match. You could choose 5 of the 8 clusters, 2 of the 8 clusters. You could team up with someone who was taking 2 and I'm taking 3 and join up. So there was various combinations which were brought in. The idea being to see if, Mr. X chooses 3, but allocates nominal value to the remaining 5. You might find 2 others who allocate significant value to 2 of those 5 and 3 of those 5. So together, the 3 of them will give a lot more value for the CIC as a whole. And so again, that experiment was done, like it was done in Dewan housing. And values were derived. I think as the process went along, for multiple reasons, it became clear that the players who wanted the entire company, because that was also an option, you didn't have to go cluster-wise. You could also give an offer for the entire company. The players for the entire company seem to continue to be interested, and at present seem to be giving the most value. Some of the other thoughts that went on during this process, you'll be aware in the CRP regulations, there's now a line which says that if a resolution is effectively not satisfactory for the COC, a resolution plan which has been received, then the COC may determine selling pieces of the company separately. Now, what does that mean? My sense is that effectively, if the COC was to say over here, we don't like any of the resolution plans, then it could then say that I will now sell each of these business lines separately and sell them separately. And as each of them yield cash, that cash comes into the mothership, the CIC, the NDSC. And once all or most of those clusters are sold out and there's mostly only cash left, then a resolution plan really effectively is placed for that company, which mainly consists of cash and maybe a few investments, to resolve that company, which is much easier because you're just resolving a company mostly full of cash. So that may be another option which parties may think of in different companies in the future, given what the regulations permit. That has not been required so far in Reliance Capital. And what we have today is 2 bidders, the Hindujas and the Torrent Group, which are vying for the company. They're in court at the moment, fighting the same kind of fight we spoke about yesterday, which is, can you, potentially run a process, and then if there's the possibility of greater money, can you extend the process? Can you do more rounds? And that is the core issue which is being fought, was fought in the NCLT, has been argued in the NCLAT. We await an order. Maybe it'll come next week. And who knows whether we're in the Supreme Court or not. But that is more or less what I had to say in terms of the structure of resolution. And I'll pause here because I'm conscious this is a fairly contested, complex point, and see if there are any questions before I move on to my next point in the RCAP saga.
Participants can ask questions if they have. I request the participants to ask the questions, or they can put the questions in the chat box.
Or Adhika, I can continue and maybe people can ask questions at the end. I thought I'll just pause, given that this was such a unusual concept. I thought people may have immediate questions.
It makes sense, Nilang, because then, otherwise we get derailed a little bit. I think we leave it for the end.
So Mr. Bharat Upadhyay has raised his hand.
All right. Okay.
Mr. Bharat Upadhyay, if you have any questions for us.
That may just be a mistake. Why don't I plow on, as Mr. Bhatta says, and then take questions at the end. Okay. So that was, a unique development and a process which we ran in RCAP. And I suspect there'll be more of this coming through. You'll have seen also, and Mr. Bhatta will know all about this, the recommendations made, in the MCA working paper in relation to changes to the IBC. There are also suggestions over there that the law now, not only the regulation, the law should be changed to allow for resolutions of separate business lines in a company. And I think one of the counter arguments I heard the other day is, but isn't that effectively liquidation in a resolution process if you're allowed to sell off entire asset lines separately? And I suppose my answer to that is, the idea, of course, of allowing this is to sell separate business lines and not, individual assets. You don't sell the steel plant and then the power plant and then the pipeline and so on and so forth separately. The idea is to sell maybe the steel plant here, maybe the shipping line over there, etc. So as long as you can sell business lines separately, that should be permitted. And the other argument which is made against this is, but isn't this liquidation in a resolution process? To which my response is, well, the COC is perfectly entitled even today, in the first COC meeting, to resolve for liquidation. First COC meeting, they can say resolution nahi karna hai humko, I will go for liquidation. Chances are the court is going to say, wait a minute, why are you going to liquidation? Have you thought about resolution? And therefore that will have to be justified. So if the law has already taken a policy decision to permit an early liquidation in a resolution, I don't think it's a significant policy leap then to allow an individual asset or business line sale during resolution, even if that is analogous to liquidation in resolution. But I move on. The other significant issue which we have encountered, which variants of which some of you may have encountered in your processes, is what happens to an asset of the company which has been secured to a lender, on which asset enforcement is started but not completed. And the possession has moved, although the title has not moved, to the lender. Right? I'll say that again. Asset of the company, security given to lender. Lender started enforcement before IBC, but not completed. And therefore, today enforcement is pending, it's not completed. The title remains with the corporate debtor, but possession has moved to the lender. An easy example is a pledge of shares. Right? Now, given where the law of the land stands in the Supreme Court order in PTC, in order to enforce, you need to sell the shares, or enforce a pledge, you need to sell the shares to a third party. You cannot merely enforce a pledge by moving shares from a demat account of the corporate debtor to yourself. That is not enforcement complete. That is only the first stage. You actually need to run a process and sell the shares to third parties. So what happens in the middle if the CRT comes in the middle, where the shares are moved to the lender but not being sold to a third party? Now, first question is, can those shares which have moved to the lender be sold during IBC? Answer is no. There's moratorium because the asset still belongs to the corporate debtor. Title still remains with the corporate debtor. So moratorium applies. So cannot sell. So the lender possesses, holds, does not own, but has a physical grasp over the asset, but cannot sell. Does the security remain? The argument is possibly yes. Why not? Because he has started enforcing the security but not completed. So surely the argument should not be that he has lost his security. So asset remains, corporate debtor, lender cannot sell it, moratorium applies, security of lender remains. So abhi kya karna hai? Obviously, any resolution applicant of the company is going to say, I am buying your company. I own that asset. You may own the asset legally, it may be in your balance sheet, but physically it's been possessed by a lender. Give it back to me. How do I know I'll get it? Now, I think if a resolution applicant makes this argument, I think it's a little bit of a red herring. Because quite frankly, no one is going to tell a resolution applicant, you give me the money, whether you get that asset or not, hum dekh lenge. Right? So inevitably, he can put it very simply in the plan and say, listen, I'm giving you 100 rupees, but my precondition is that lender has to transfer the asset back to me or back to the corporate debtor. So I think from the RA perspective, it is not complicated. But as an RP perspective, is it complicated? I think you need to think about that. What is your duty if you look at the IBC? Protect and preserve the asset. Take custody of the asset. So if your corporate debtor shares are sitting in the lender's demat account because of a partial enforcement, your job is to get it back into your possession. Now, how do you do that? You can ask the lender. The lender may say yes, lender may say no. What happens if the lender says no? And that is what we have hit in our case. And again, this is in the newspapers and it's in the court. It's being argued out in NCLT. We have gone to court and said, listen, we have no objection to the security, assuming it's been validly created. We are not objecting. We are not arguing to the pledge enforcement before. That is not relevant anymore. There's a moratorium. But the title is ours. That is undisputed. It is my duty to take custody, my duty to protect and preserve. It is relevant for whatever reason to my resolution applicant because they are getting very worried. And therefore, you please hand the shares back to me so they can stay in my possession. And whether or not the NCLT will direct the lender to hand the shares back to me as the administrator is now the question pending before the NCLT. So this is going to be another interesting one. I think the answer is pretty clear, but given that I'm on the administrator's side as legal counsel, I should not necessarily profess my views and let the court decide. So we should hear a decision hopefully this quarter. Now that is on possession. The third issue I want to talk about, which also is quite interesting, is how there's a resolution within a resolution. So as I was telling you earlier, RCAP has two NBFCs under it: Reliance Home Finance, Reliance Commercial Finance. It holds 100% of one, 48% of the other. Both of those are also in distress. Think a few thousands of crores, maybe 10,000 crores or some such of each of them of outstanding debt. Each of them have gone through a June 7th resolution or are going through and have reached the end. For Reliance Commercial Finance, the winning bidder was Autumn. Bank of Baroda was the lead bank. Now, what happens in a June 7th resolution? This is not an IBC process. It is, as you know, more of a contractual process. Lenders have to get together. There has to be an ICA. There has to be a share transfer. There has to be a dilution of equity, capital reduction, something has to be agreed, but all parties have to more or less give their consent. Like the IBC, which comes in and chops out directors and chops out shareholders and chops out 33% of lenders' vote. वो नहीं होता June 7. So therefore, effectively, what has happened is for Reliance Commercial Finance to go through, you need the cooperation of RCAP as a 100% shareholder. And therefore, the COC of RCAP had to basically say, yes, as long as you're doing a June 7th resolution, as long as your resolution is valid, and as long, therefore, the lead bank comes and asks me to transfer the shares, I will. And that's what's happened, effectively, in Reliance Commercial Finance. From a COC perspective, they have approved the sale of shares to the winning bidder Autumn. And therefore, that resolution is complete, at least from our perspective, where the shares have been transferred and the debt is being, has been resolved or is being resolved. We are not involved over there. We were just shareholders, if you think about it. But an interesting thing to keep in mind over here is that I am a company already in administration, already in IBC. My subsidiary is going through an insolvency resolution process. And in that process, I am being asked to take my investment, my asset, and sell it. How do I do that? This is not a resolution of a business line. This is simply sale of one asset. So here we've used what we call Reg 29. This is very different from the structure I talked about, where the CIC is being resolved through different business clusters. This is not that. This is simply a Reg 29 sale, where we have taken the permission of the COC to the extent they have security over these shares, release the security, and sell this for a nominal amount, because obviously the equity in this company is not worth very much. There were also other aspects in relation to resolution of Reliance Commercial Finance, which relate to the debt exposure of Reliance Capital in Reliance Commercial Finance. So Reliance Capital had also lent money, just like other banks had lent. Reliance Capital had also lent. And over here, the view taken by the lead bank and the creditors in Reliance Commercial Finance was that being intergroup debt, or rather intercompany debt, or promoter debt, so to speak, that money should not receive any payout. And therefore, the debt exposure of Reliance Capital in Reliance Commercial Finance has not received the same payout as the other secured lenders or unsecured lenders of Reliance Commercial Finance, being related party debt. Now, this concept is more commercial than legal. There is no restriction, as you are aware in IBC also now, for payment to be made to related party for their debt. But often lenders take the view that we will not pay any related party debt, any promoter debt. There's another company like this called Reliance Home Finance that is still being resolved under the June 7th. This is another NBFC where we hold 48%. Potential is over here that Reliance Home Finance may not be resolved before the end of the process. So the question is, what happens if Reliance Capital gets resolved before Reliance Home Finance gets resolved? Effectively, the new bidder for Reliance Capital will also get Reliance Home Finance because that's a subsidiary. But some bidders have said that we may not want Reliance Home Finance. That is not a subsidiary we want. It is not relevant to us. हमको वो झंझट नहीं चाहिए. So how do we get around this? One of the structures which has been discussed is that in this scenario, what the bidders could do is they could carve out the subsidiary, drop it into a trust, and hand the beneficial interest in that trust back to the COC and say, "Bhai, aap hi rakho until the resolution downstream gets completed, and then you do what you want with the share. But we don't want it as the RA, you keep it." That is one structure which has been thought of. Obviously, regulatory muster, regulatory analysis, etc., has to be contemplated. We need to think about that. But just for you to keep in mind, a tricky asset which is lying in the company, which the PRA doesn't want, this is maybe one solution in other equivalent cases you may be running to resolve that, where the RA is saying, "I don't want it, how do I fix for it?" Drop it in a trust, hand the beneficial interest back to the COC. Now, one issue which has come up quite significantly in relation to RCAP and has come up in relation to Reliance Commercial Finance and Reliance Home Finance is these companies have issued lots of debentures. Now, the way debentures are issued is the company will sign one debenture trust deed, state debenture trust deed dated 30th April 2021. It will sign that with the debenture trust deed and say, under this debenture trust deed, I will issue 1,000 crores of debentures from time to time. Then what happens is, after they've issue this debenture trust deed, from time to time the company actually issues debentures. First they will issue 2,000, then 1,000, then 3,000, then 1,000. Sometimes, even though they are under the same debenture trust deed, they will be issued under different information memorandums. And as a result, their terms will be different. So there could be 4 debenture issuances under one debenture trust deed with 4 different IMs and with different terms and with different, importantly, different ISIN numbers, which is the security identification number. Which means that you could have one debenture, I could have one debenture, Suresh could have one debenture. All of them issued under the same debenture trust deed, but different ISIN numbers and slightly different terms. He could have 7%, I could have 5%, you could have 3%, whatever it is. Now the question is, how do we vote? Right? Let's say let's simplify it. There are only 3 debenture issuances in the company, all under one debenture trust deed, all 3 with different ISINs. Debenture ISIN number 1, debenture ISIN number 2, and debenture ISIN number 3. I have number 3. Suresh is number 2, you have number 1. Your debenture is 100 rupees. And ISIN number 1, you are the only debenture holder. Suresh holds a debenture number 2, ISIN number 2, worth 50 rupees. But that debenture issuance over there is 2,000 rupees, of which he holds 50 rupees. But he is the only active debenture holder. The others don't even come to vote. And the third is me. I hold debenture number 3, ISIN number 3, 300 rupees. The total debenture issuance there is 400 rupees. So I hold 300 of the 400. Now, what is the total? I hold debentures in an issuance of 400. You hold 100. Suresh holds 2,000. Total debt of the company is 2,500. Correct? But there are only 3 active debenture holders. One is you holding 100. One is Suresh holding 50. One is me holding 300. Now, if you are aware, the voting of debenture holders is present in voting. It is not like in a COC, which means that if in Suresh's ISIN, 2,000 mein se only he shows up, then he becomes a denominator also. So in his debenture, It will show as 100 voted yes divided by 100. End of matter. Or sorry, 50 or whatever his number was. Which means that the remaining people don't vote. It is not considered no, like it is in a normal COC. What does that mean? Now it becomes very important if you see my example, in terms of whether we regard the voting by ISIN or DTD. Why? There are only 3 active debenture holders. You, Suvash, and me. You have 100, yes, 50, I have 300. So if it is considered the voting is done by DTD, the 3 of us will vote. Only 3 of us will vote. Everyone else is sleeping. The 3 of us together constitute 450 rupees. I am 300. Which means whatever I say applies to both of you as well. As opposed to voting by ISIN. If it is voting by ISIN, you hold 100 rupees of your 100 rupees. So you can vote yes or no for yourself. Suvash is the only one who votes in his debenture issuance. So his answer will be the vote for his ISIN, and mine will be for mine. So you could say no, Suvash could say no, I could say yes, and my yes will only apply to my yes, to my debentures, if it is ISIN voting. If it is debenture voting, my yes becomes your yes, becomes Suvash's yes. So you see, debenture trust deed versus ISIN voting is a very important discussion. Now, SEBI issued a circular in October 21, I think, saying that in June 7 kind of resolutions and so on, the voting should happen by ISIN basis. Now, I won't go into the merits of whether ISIN is better, DTD is better. There are arguments both ways. That is not relevant to this discussion. I think in Reliance Commercial Finance, the view was taken that no, the voting will be done debenture trust deed wise. And at least in Reliance Commercial Finance, depending on whether the voting happened debenture trust deed wise or ISIN wise, the answer was very different. And eventually, the Supreme Court decided on other parameters that Reliance Commercial Finance could continue with the debenture trust deed voting, and that got resolved. But that principle also equally applies to Reliance Capital, because we also have a lot of debentures, and the question is, how do you vote? Debenture trust deed wise or ISIN wise? And I think that the view that has been taken for now is that under the IBC, and I won't go into the relevant sections, but you can ask me separately. Under the relevant sections, in particular section 21, 25, etc., the language of IBC suggests that the document that appoints the debenture trustee, which is the debenture trustee, is the document that governs how voting will be done, i.e., voting should be debenture trustee wise, not ISIN wise. So that seems to be the current view in the market across market participants and law firms. And that seems to be the current view that has been followed. And I wanted to make this point because this is very important from the perspective not only, I suppose, of debenture issuances, but any other such groups which are represented by an authorized representative, which between themselves behind the scenes have different interests, and whether you should consider them separately or as a group. In terms of what's happening today in Reliance Capital, the last thing I wanted to discuss was the ongoing issue in the NCLAT in terms of whether or not the COC is allowed to extend the bidding process in a manner which it deems fit in order to maximize value. So what are the facts over here in Reliance Capital? An expression of interest went out. Parties bid. The bids received were not satisfactory for the COC. The COC said, we will run a further process, a challenge mechanism. It set out a challenge mechanism note. 4 parties participated in this challenge mechanism. 2 parties fell away halfway through. 2 parties stayed till the end. In that process, one of the two bidders seemed to have come on top. That person obviously thought that process is over. Company is mine, hopefully. A day later, one of the other bidders came in and said, actually, this is my offer. Now, whether that offer was different, was it increased or not, I won't go into, that is all sub judice. But certainly the other party thought that that offer was different and so went to court and said, not allowed, process is over, no one can then come in and offer more money. Court said yes, NCLT agreed, not permitted. COC thought about it. COC said, you know what? This is neither here nor there. Whether I'm allowed to, whether that offer was more, not more, whether I want to accept it, not accept it, allowed to accept it, not relevant. I don't like either offer. Both offers, less or more, are not satisfactory to me. I want a lot more money. COC decided. So I will now have one more round of the challenge mechanism. To which one party said, no, you're not permitted. This is what your challenge mechanism says. COC said, nay. This is what I meant. We are back in court and flat. Now, question is, really, from a value maximization perspective, is the COC entitled to run an extra level of a challenge mechanism? Or is it bound if there is some language which suggests, or the bidders feel suggested, that that was closure? Is there some element of expectation of entitlement that the bidder should have to say, bhai, aapne bola tha ki wo hi khatam hoga, the line is drawn over there and that is where it will end? Or can the COC say, no, either I did not say the line was drawn over there, or even if I said, I can redraw the line and say you raised till there now because I want more money. And this is going to be very interesting because, as I was even mentioning yesterday, which some of you may have heard, is that from a principle of behavioral economics, is a bidder going to offer more money if he knows final means final? Or is the COC going to get more money if even after saying final, it can tell someone, give me more money? Now, I don't think we'll have a definite answer on that behavioral economic principle, but we should have a definitive answer from the courts on which one is permitted. Now, you will be aware there's a regulation 39(1)A, I think someone just messaged in the group, that you can only change the resolution plan once. I think that's right. But the way the regulation is worded, I want to make 2 points. Is it says resolution plan, i.e. signed resolution plan. So some market participants are taking the view that if you give me a signed resolution plan today, on Tuesday, saying that I offer you 100 rupees, I can then sit with you from Tuesday to Friday and negotiate and say 100 ka 110, 130, 140. And in that process, get draft resolution plans, draft financial proposals from you for me to consider. And once by Friday we agree 160, then you submit a second signed resolution plan and therefore comply with 39(1)A. That is one view in the market. There are other more conservative views, there are other more stricter views, etc., along that range. But note that NCLT Chennai seems to have said that 39(1)A not applicable to COC. COC can ask for more resolution plans. Jindal Steel again was an NCLT matter which went to NCLAT, where actually the COC took the other view. COC said that even though someone has paid me more, I don't want it, Baba. I finished my process. The NCLT over there said, nay, how can you let go of the money? You please consider. You're entitled to consider, please consider. You're not limited by 39(1)A. NCLAT then said, listen, please, let the COC decide what it wants. It's not forced to consider more if it doesn't want to. So that is Jindal Steel. Then we have NCLT Chennai, which has said no, 39(1)A not applicable to COC. And now we have RCAP, which is again an NCLAT. So let's see if we now finally in NCLAT get an accumulation of these slightly contrary views into one more guiding principle. that was it in terms of my ramble on the RCAP process. I don't know if anyone has any questions, Mr. Bhatta, if you'd suggest I talk about anything more on any of these topics, or.
No, I mean, I think this is very insightful, Nilang. I mean, all the 3 cases that you've discussed so comprehensive. I've learned so much because I didn't really know, all these finer details. Of course, what you read or hear from the stakeholders when they come to talk to you about certain things. So I don't have any question per se, but let's see if the participants have. And so, Radhika, I mean, how do you want to go about this? Nilang, do you want to cover something else also, or should we just keep it open now?
I think in terms of FSP insolvencies, I was about done. But if the audience has a particular aspect of the law they would want me to talk about, and if I'm familiar with it, I'm happy to speak more on it.
So, Radhika, I think it might just be a good idea to open it for questions and see how.
Yes.
I think what we just need to politely request everybody is to sort of center the questions on the FSP issues. And at the end, if we have a few minutes, we can take some general questions, but it does become kind of an issue. You need to answer questions which are more specific to a particular case and are more in the nature of an opinion. But on FSP, yes, academically, scholarly, legally, operationally, anything which they would like to know, and we should ask.
Participants can ask the question on FSP if they have any, or they can write in the chat box.
Sir, are you permitting question only for a special vakil or any other question relating to IBC also?
So first of all on FSP, and then we can take it afterwards, the general question.
Okay.
I think Mr. Upadhyay had a question. I can see.
I think his hand may have been up by mistake. It's been up for a while.
Possible.
Participants can write the questions in the chat box. I guess no more questions are there with the participants.
I'm also conscious, Radhika, that FSPs have only been 3, and one is not sure when the next one will be. So in terms of practical, immediate relevance of FSP may not be as relevant to this wider group, but I'm hoping we brought out some principles which may by extension also apply to non-financial firms.
Yes.
True, especially like the group insolvency, the sale of assets, how do you deal with the subsidiaries' assets, how do you... So those are issues that are universal. They may have been tested in the case of FSP, but they would apply in other corporate debtors as well. So I think that it was a useful insight from the other dimensions as well. Maybe, if there are no questions, I think perhaps what we could do is maybe, it's 3:47, maybe give 15 minutes as open floor if somebody has any general question on anything on IBC or.
Yes.
May I raise one issue, sir?
Yes, of course. So you can ask the question.
Yeah, I have one query. There is a situation that the assets of the CD charged to some bank, and the value of the assets is maybe around 8 crore or something like that. And in the given circumstances, RP was need of some fund to run the CD as a going concern. Hence, he obtained interim finance, maybe around 1 crore or something like that, by charging the same assets which was charged in favor of a bank. The question here is, do the IRP has authority to raise this finance, basically, as per IBC? The question is whether it is necessary to take consent of COC, or IRP has inherent power to raise this finance, which was otherwise secured with the bank.
So, Nilang, can I just answer
Please,
maybe
please.
and maybe you can supplement it then?
Please.
So you see, there is no inherent power, as far as this is concerned. There is a power that interim resolution professional has before the COC is constituted to raise interim finance, but he has to still satisfy the conditions that are mentioned in the relevant provision. And once the COC is constituted, there is no way the interim finance can be raised without the approval of the COC. And it is then for the COC to decide whether they are willing to cede second charge on the assets in favor of the interim finance provider, or if they are willing to give agree to a charge being created on an asset which is not encumbered at the moment. I think that's entirely a prerogative of the COC. The RP can't do anything. I mean, I would even be doubtful if the NCLT has that power. NCLT has processive power over the lenders. Yeah, but we do understand that there are certain directions with regard to the paying of the CIP costs, which would be treated as interim finance and which can be paid as CIP cost and in priority as an interim finance would be paid, but that is not really akin to a raising of interim finance in the first place. These are my short comments.
Sir, section 20 somewhere deals with this kind of thing, I think. To raise interim finance provided that no security interest shall be created over any encumbered property of the CD without the prior consent of the creditor whose debt is secured over such encumbered property. Then there is a proviso, provided that no prior consent of the creditor shall be required where the value of such property is not less than the amount equivalent to the twice of the amount of debt. So, the IRP is saying that he's having some power in regard to the borrowing, and he's trying to justify his borrowing basically. We are just trying to accumulate whether he's on the right foot or not.
Nilang, why did you take this?
Sure. So I don't necessarily want to pass any sort of judgment here. I think maybe the counter argument that this IP might be thinking of making is, I think if you look at the way the IBC reads, it says that this the IP in relation to raising interim finance, if it's over the level which has been set by the COC, maybe what the argument he's making is the COC never set a level. And therefore, he's entitled to raise whatever finance he wants. I think in practice, what we've seen is, as Mr. Batra points out, that IPs tend not to raise interim finance without COC approval, because why have that fight? It's ridiculous. And even the interim finance provider will not want to get into a company where there is a moratorium and therefore it can't, effectively challenge the company. And therefore, why should it get into a company where the COC is unhappy with the interim finance? Why put money into a company where the lenders are going to fight? So, maybe they have some legal argument or legal counter argument over here, but I would have thought that this will be a tough call made by the IP, certainly in terms of the finance raised. I think in relation to the security, as a matter of practice, I think 2 or 3 things, right? If it's unencumbered, even if it is unencumbered, my sense was that from an IBC perspective, to give security is, in a sense, disposing of an asset or an interest in the asset. And that by itself, during the IBC, is permitted only within very limited perspectives. So I think giving security during IBC is something which has to be examined a little more closely in the first instance. Secondly, someone already has security over it. Then, as a matter of simple, the law of security, to give security over that asset without the consent of the existing exclusive or first charge holder will depend on what the language of that security says, especially if it's exclusive and it says no security may be given without my consent. To override that, I'm not sure if the IBC gives power. So that's something also which needs to be examined. And I think the third point is the proviso which you read is, I think, a relevant proviso, but suffers from the practical issues which I just mentioned. So the three of these issues need to be read together before taking a final view.
All right. So there's one question being put up by Mr. Bharat Upadhyay. He has mentioned how it trigger in case of FSP. Only RBI, suo motu, or creditors can make petition.
Only RBI. That's very clear in the FSP rules. I think the creditor can go and present the petition or the case to the RBI and request for whatever reason that the relevant financial service provider should be put into IBC, and the regulator may consider. In fact, I think there were some news reports that lenders of either Reliance Home Finance or Commercial Finance or both even had approached the RBI to request them to put those companies also into the IBC. So like that, the creditor can petition the RBI, not the NCLT.
Then the next question is how voluntary liquidation happen in case of FSP?
It's permitted, again, the FSP rules contemplated. But again, I think the FSP needs to approach the RBI again and seek his permission to go under voluntary liquidation.
All right, sir. Next question is what challenges specific to FSP you foresee, particularly while realizing foreign receivables?
I don't think realizing foreign receivables has a particular dynamic in the context of an FSP insolvency, as much as it would apply to recovering foreign receivables in any other IBC. But sorry, Mr. Batra, I don't know if you have a different view on that.
No, I'm good with that, yes.
And I suppose recovering foreign receivables, in a sense, would be, no different really in a solvent company versus an insolvent company, in the sense that you just need to approach the relevant foreign counsel and authorities to recover those assets. And I suppose at some point, if those assets are sitting in a foreign company which is also insolvent, and then there needs to be some coordination to be done between the administrator of that company and the administrator of this company, then that coordination, at least today, will have to be relied on basis, what is called the Committee of Courts and Committee of Insolvency Professionals. I think as Mr. Batra pioneered in Jet Airways along with some of my partners, where effectively, the courts got together or the professionals got together along with the advisors and, developed a protocol to, resolve any insolvency issues and asset resolutions.
Sir, in that case, hello. Am I audible?
Yes, sir.
In that case, that timeline should be certainly, will be tossed. So, what might be the recourse in that case?
Sorry, I'm not sure I followed the question. The timelines will be pushed out, you're saying?
Yeah. That will surely cross because, foreign receivables are getting those realizing.
No, we are seeing that, right? We are seeing that in a couple of cases where the overseas process is taking a lot of time. But I mean, the short point is if there's a resolution of the company, the resolution applicant will buy whatever value he attributes to that claim. Or if it goes to liquidation, the liquidator can then continue processing recovery of that claim. I'm not sure the court will necessarily extend the resolution process because one or two assets need resolution overseas, is the short point. Unless they constitute almost the entirety of the assets. And you could argue that there's a litigation in relation to those overseas assets, and therefore that litigation should be excluded from a 330-day period. I mean, I suppose that argument could be made.
The next question is, in one CIRP after 12A filed and pending for disposal by NCLT, RP needed funds for CD. COC said, we will not fund promoter offered funds. Then he has written, question is incomplete, I guess. Can RP go ahead and then seek NCLT's consent, or he can go for ratification?
I'm not sure I followed the question, so I don't know, Mr. Batra, if you did.
I think what is being suggested is that the promoter who had moved the 12A stepped forward to provide the funds to keep the enterprise as a going concern.
So just a second, I'll just mute them.
So the question is that can RP accept the contribution made by the promoter without, and then ultimately get it ratified from the NCLT. Now, the fact is that as long as the promoter is, my view on this is that if the promoter is funding without seeking anything in return as a priority, as a CRP cost, or in any manner prejudicing any other creditor or wanting to get paid before payments are made to other creditors, I see no reason why there should be difficulty. He's at the end only trying to preserve the value and making sure that there's no disruption caused in the absence of the availability of funds, which no lender is willing to give at this stage because of the obvious reasons that there is a Section 12A pending, and they're hoping that Section 12 is allowed and the lenders get paid the way they have agreed, and the CRP comes to an end. So why would they put any money? And if the promoter is putting it, it's absolutely fine. I mean, he is not wanting to claim over here, as long as he's not wanting to claim any priority interest in that, is not in any way going to ask that payment to be made over and above what he has agreed to pay to creditors. I don't see this as a difficulty. I think he can do it, and then NCLT will be very happy to take that on record. I don't even think that any ratification is required in that sense.
No more questions in the chat box. Participants can ask the questions if they have, or they can write the question in the chat box.
Again, my request would be that please, if you could ask the general proposition of law rather than being very specific to your case is in the nature of an opinion, because we feel we are very happy to provide an opinion. At least I'm happy to provide any view of this, but it may not be proper for us to be opining on a particular case and and giving it a view without really knowing the full facts on the basis of just a 3-line question. It could be, at times be completely misleading. So we just want to be completely transparent and candid about it in that sense.
So one more question, Mr. Sushil Kumar has written, is IBC failed in respect of real estate companies unable to hand over thousands of flats?
Well, if I can take this question, I know it's very hard to express an opinion such as this. I know it's a strong view that you express that that has it failed. I would really like to answer the question more specifically in that sense. But what I would suggest is that yes, there have been a number of challenges in the real estate enterprise. Is something which you all know. This is not any secret, but over a period of time, through innovation, through judicial interventions, through policy interventions, we have been able to fairly improve the processes, improve the whole efficiency of the process, deal with the challenges and the pitfalls that we have experienced. And I can see that even in the discussion paper that the MCA issued in December, we had seen that there are a number of other significant changes that are expected to deal with the complexities or the challenges that we continue to face. So I do believe that there are challenges, but there have been adequate measure in the past, and I believe that we continue to. And over a period of time, we will hopefully be able to make the whole process of real estate enterprises insolvency resolution more efficient. I'll stop at that, Sushilji.
Thank you.
No more questions are there in the chat box, sir. So we can conclude the session. So on behalf of Team ICSI IB, I would like to thank all the participants for joining the session and for both the sessions yesterday and today. And would like to thank you, Suman sir, for all your support. And I would like to thank Nilang Desai sir and all the team members, Ms. Amrita, Mr. Suharshina, and Mr. Avinash Subramaniam for taking up all the matters and discussing it in detail. Thank you so much.
I will also like to thank Nilang, Suharsh, Avinash, and Amrita for their contributions and for taking out the time with 2 days. And Radhika, thank you so much for you also for coordinating with us. And thank you for that.
Thank you.
Madam, may I request you to mark my attendance? I was stuck up in NCLT hearing at up to 3:15.
So we will be sending a separate mail for that. Be assured.
Thank you.
Thank you.
Thank you.
Thank you.